Good evening, all of you. First of all, thanks for giving this opportunity for Safi sir. And my review class topic is living relationship. I am Vigneshwaran, lecturer GLC Theniat in Tamil Nadu. I hope you all understood in Tamil, so I took bilingual in English and Tamil. First of all, living relationship in India. The term living relationship might be new. The term is new, but the concept is the ancient itself is there. According to Manusmriti, in the Vedic period and afterwards, pre-material marital relationship existed, but were of rare occurrence. So, and the living relationship அப்படின்ற ஒரு term இன்ட்ரடியூஸ் பண்ணுறது ஒரு நியூ டேர்ம், பட் அந்த கான்செப்ட் அப்படின்ற ஒரு எக்ஸிஸ்டிங்காக இருந்தது வந்து மனு ஸ்மிருதிலேயே வேதிக் பீரியடில் வந்து எக்ஸிஸ்டிங் ஒன். In the Vedas, we find acknowledgement of 8 types of marriage. We all studied in Family Law 1 the 8 types of Hindu marriage: 4 approved marriage, 4 unapproved marriage. The 4 approved marriage is Brahma, Daiva, Arsha, Prajapatya. It's a 4 approved marriage. And 4 unapproved marriages: Gandharva, Asura, Rakshasa, Vaishacha. The 4 is the unapproved marriage. The one of the unapproved marriage is Gandharva. So, on the Gandharva form of marriage, and man and woman mutually decided to live together, like love marriage without consent of parents. So, that and the concept of a living relationship existing in through like Gandharva marriage in the ancient period. It's mentioned in Manusmriti. This is the introduction of living relationship in India. Next, living relationships. Before moving to the living relationship concept, we go through the Hindus and Muslims Christian marriage. We all studied in Family Law 1 itself. ஒரு ஹிந்து மேரேஜ்னா, ஒரு முஸ்லீம் மேரேஜ், கிறிஸ்டின் மேரேஜ் எப்படி வந்து நம்ம அது வேலிடிட்டி என்ன, அந்த வேலிடிட்டி ஆஃப் மேரேஜ் வந்து வேலிடிட்டி ஆஃப் மேரேஜுக்கு அப்புறம் அந்த ஒரு சைல்டை எப்படி அடாப்ட் பண்ணணும், ப்ளஸ் அந்த பார்ன் அவுட் ஆஃப் சச் ரிலேஷன்ஷிப் லைக் லெஜிட்டிமேட் சைல்டா இல்லை இல்லெஜிட்டிமேட் சைல்டா அப்படின்ற ஒரு கான்செப்ட் எல்லாம் நம்ம ஹிந்து மேரேஜ் ஆக்ட் செக்ஷன் வைஸாக நம்ம பார்த்துருப்போம். முஸ்லீம் மேரேஜில் கஸ்டமரி ப்ராக்டிஸ் வைஸாக நம்ம பார்த்துருப்போம். At the same Hindu marriage sacred bond and Muslim law considered as a contract, we study in Family Law 1. But the living together in a relationship and having a sex without getting married, there need to be a rules established for living relationship. There is no rules till now. There is no rules established for living together in a relationship, having sex without getting married. அந்த ஹிந்து மேரேஜ் முஸ்லீம் மேரேஜ் ரிலேட்டடாக இருக்கிற அடாப்ஷன் ரிலேட்டடாக லைக் ஹிந்து மெயின்டெனன்ஸ் அண்ட் அடாப்ஷன் ஆக்ட், ஹிந்து அடாப்ஷன் அண்ட் மெயின்டெனன்ஸ் ஆக்ட், ஹிந்து மைனாரிட்டி அண்ட் கார்டியன்ஷிப் ஆக்ட், இந்த மாதிரி ஆக்ட்லாம் வந்து அந்த கார்டியன்ஷிப் ரிலேட்டடாக அந்த மெயின்டெனன்ஸ் ரிலேட்டடாக ஆக்ட்ஸ் எல்லாம் நம்ம பார்த்துருக்கோம் ஹிந்துஸ் ரிலேட்டடாக. முஸ்லீம்ஸ்க்கு வந்து நம்ம டிஃப்ரெண்ட் கஸ்டமரி ப்ராக்டிஸ் வந்து ஃபாலோ பண்ணியிருக்கோம். ஆனால் லிவிங் டுகெதருக்கு வந்து does not there is need to be a rules established for living relationship too. The 3 questions is there. They can living partners adopted kids. ஒரு லிவிங் பார்ட்னர் வந்து அடாப்ட் பண்ண முடியுமா கிட்ஸை? What about the status of kids born out of such relationship? அந்த அது லெஜிட்டிமேசி சைல்டா இல்லை இல்லெஜிட்டிமேட் சைல்டா அப்படின்றது ஒரு ரூல்ஸ் கிடையாது லிவிங் ரிலேஷன்ஷிப். அண்ட் இன் கேஸ் ஆஃப் டிஸ்பியூட் அண்ட் பிரேக்கிங் அப் ஷுட் பி மெயின்டெனன்ஸ் கிவன் பை எய்தர் ஆஃப் த பார்ட்டிஸ். Here does not mentioned husband and wife relationship. Here mentioned only parties and partner. லிவிங் ரிலேஷன்ஷிப்பில் இந்த பார்ட்னர்ஸை வந்து பார்ட்னர்ஸ் மட்டும் மென்ஷன் பண்ணுவாங்க, பார்ட்டிஸ் மென்ஷன் பண்ணுவாங்க. ஹஸ்பண்ட் அண்ட் ஒய்ஃப் அப்படின்ற ஒரு டேர்ம்ஸ் மென்ஷன் பண்ண மாட்டாங்க. அப்போது அந்த ஒய்ஃப் அப்படின்ற ஒரு டேர்மு கீழே வந்தால் மட்டும்தான் சிஆர்பிசி 125ல வந்து நம்ம மெயின்டெனன்ஸ் கிளைம் பண்ண முடியும். அப்போது லிவிங் ரிலேஷன்ஷிப்பில் அந்த ஒய்ஃப் அப்படின்ற ஒரு டேர்ம் வராமல் எப்படி அவங்க ஒய்ஃப் மெயின்டெனன்ஸ் கிளைம் பண்ண முடியும் அப்படின்றத இந்த 3 types ஆஃப் கொஸ்டின்ஸ் வந்து நம்ம ஃபர்தர் ஸ்லைடில் வந்து நம்ம டிஸ்கஸ் பண்ண போகிறோம். The 3 main area of dispute regarding living relationship. The 3 main disputes is that first dispute is legal validity of relationship. இப்போ லிவிங் ரிலேஷன்ஷிப்ன்றது ஒன் ஆஃப் த லீகல் வேலிடிட்டி இருக்கா இல்லையா in India? The short answer is not illegal. Do it legally in India. Okay. Second question is, what are the rights of parties? That parties, not a husband and wife, parties, living relationship parties. The 3 types of rights. 3 rights is there. One is the maintenance rights and protection of women from domestic violence act. Domestic violence rights. And whether adoption right is there, 3 types of rights வந்து நம்ம டிஸ்கஸ் பண்ண போகிறோம் ஃபர்தர் ஸ்லைடில். The 3 types of rights-க்கும் not yet framed any rules regarding living relationship. What are the rights of children born out of such relationship? அப்போ அந்த சில்ட்ரன் வந்து born out of such relationship, it's a legitimacy children or illegitimacy children. அந்த கொஸ்டினுக்கு நம்ம ஆன்சர் பார்க்க போகிறோம். These kind of disputes related legislation is scarce on living relationships, so most position of law are derived from case laws. So there is no legislation till now. So the 3 disputes derived from case law itself, judgment law only, not a legislation. There is no legislation for this kind of disputes. The first dispute is a legal validity of relationship. That legal validity of that living relationship, it's not illegal in India. You can totally do it legally, derived under the following judgments. The first judgment is yes, Kuspo vs. Kanniammal and others in 2010. The court held that living together is a right to live under Article 21. And another case in 2011, Ravana Shittappa versus Mallikarjun. The judiciary has kept in mind various factors including both the societal norms and constitutional value. You can allow the living relationship, but the judiciary has kept in mind various factors including both the societal norms and constitutional values. And another judgment in 2014, P.L. Sarma versus Superintendent Nari Nikedan Kalinderi Vigar Agra 2014. The court said that a man and woman living together without getting married, it may be immoral for the society, but it's not illegal. It may be immoral for the society, but it's not illegal. So you can do it legally. The first dispute is we discussed. That second dispute is, what are the rights of parties? I already said 3 types of rights. One, maintenance rights, domestic violence, and adoption. The first right is maintenance to the wife. Whether the partners of a living relationship can claim maintenance under section 125 CRPC. Here, not a wife, the term not mentioned wife. Here, partners of a living relationship can claim maintenance under Section 125 CRPC? Yes, she can claim, but not comes under the term called wife. The term called the term wife includes woman. The Malamute Committee 2003, the Section 125 CRPC, wife includes women, but who are not the wife and or living under a living relationship. Okay. The Shanmuniva versus Virendra Kumar Singh Kuswa 2011, the women in living relationship are equally entitled to all the claims and reliefs which are available to legally vetted wife. So the here not mentioned in the term wife. Here the term women in living relationship are equally entitled to all the claims or relief which are available to legally vetted wife. The equal to the legally vetted wife, she can claim the maintenance under 125 CRPC. And another judgment, Ajay Bardwaj versus Georgesana 2016. Here, the recommended that the word wife in Section 125 CRPC should be amended to include a woman, the word woman, who was living with the man like his wife for a reasonably long period. Here, the mentioned reasonably long period, not a specifically mentioned any limited period. Here, the maintenance to wife, as he can claim under 125 CRPC. Next, domestic violence, the protection from domestic violence. Here, the Protection of Women from Domestic Violence Act 2005 defined Section 2F of Act that defines here mentioned domestic relationship. The domestic relationship as a relationship between two persons who live or have at any point of time lived together in shared household when they are related by consanguinity marriage or through a relationship in a nature of marriage, adoption, or the family members living together as a joint family. Here, the joint family not same under Hindu law, joint family under Hindu law. Here, the joint family mentioned in living together as a joint family. As Section 2F of that protection of women from Domestic Violence Act. Here, the woman will have protection under Domestic Violence Act 2005, not the word mentioned in the wife. Here, the woman. So, the domestic relationship includes the nature of marriage and the family members in living together as a joint family, not comes under Hindu law joint family. Here, the word joint family is a secular one, the joint family. So the living partners also comes under that word joint family. The joint family words are elaborated in recent judgment. We discussed in further slide. And adoption. The adoption rights not comes under living relationship. A certain adoption resource authority, CARA, has barred couple in a living relationship from adopting a child after its steering committee held that cohabitation without marriage is not considered a stable family in India. So the living relationship is not considered as a stable family in India. So there is no adoption rights to the partners in living relationship partner. Okay. These are three rights under living relationship. And next, what are the grounds would not make it domestic relationship and living relationship? First of all, what is domestic relationship and living relationship? The first point is mentioned, what grounds comes under domestic relationship? Voluntarily cohabited. It was also, the three grounds are held in D. Veluchami versus D. Pachalammal 2010. It was also stated that the couple must have voluntarily cohabited, not involuntarily. Here, the voluntarily cohabited and held themselves out of the world as being again two spouse for a significant period of time, not a specifically mentioned the period, a significant period of time. The first point is what is the ground to the domestic relationship and living relationship. And then other two grounds are would not make it the living relationship. Simply spending a weekend together or one night stand would not make it a household relationship. So would not make it a domestic relationship and living relationship. So that second grounds also would not comes under domestic relationship. The last 2 points are the most important because of would not make it the domestic relationship. The 2 points are asked in a previous year question itself. So the second the last ground is if a man has a key whom he maintained financially and uses principally for a sexually reasons and potentially as a slave, and then it would not be considered as a relationship in nature of marriage. So the last 2 points are would not make it a domestic relationship and living relationship. The first ground is only comes under domestic relationship and living relationship. And the third dispute is rights of children born out of such relationship. That particular children is a legitimate child or illegitimate child. We know very well in Hindu Marriage Act, Section 5 is validity of marriage. So அந்த செக்ஷன் 5ல இருக்கிற அந்த கண்டிஷன்ஸ் படி நம்ம ஃபாலோ பண்ணா மட்டும்தான் the particular marriage is a valid marriage. அந்த கண்டிஷன்ஸ் ஃபுல்ஃபில் பண்ணாம இருந்தா comes under void marriage, voidable marriage. So the children of a valid marriage generally or annulled voidable marriage are treated as a legitimate for inheriting the property of their father. So the validity illama void marriage, voidable marriage la irundha and the child it's one of the legitimacy child under Hindu Marriage Act Section 16. Okay, appo void marriage nalu voidable marriage nalu annulled marriage nalu Section 16 padi that particular child comes under legitimacy child under Hindu Marriage Act. So at the same kind, whether children born out of living relationship is treated as a illegitimate and ineligible to inherit the property of the father. The answer not mentioned in any legislation held that particular two judgments. The first judgment is SPS Balasubramaniam versus Surutayan 1994. The 1994 itself, and the court may presume, not a shall presume, that Section 114, the court may presume certain facts from Article 39F of the Constitution of India. Sets the obligation of the state to give the children adequate opportunity so that they develop in proper manner and further safeguard that particular child interest, the child interest. So and the Section 114 of the Indian Evidence Act, a court may presume that the Article 39F of the Constitution of India, the state to give the children adequate opportunity. So at the same and the judgment is followed by the Madan Mohan Singh versus Rajinikanth 2010. That particular living together cannot walk in walk out relationship. So if a man and woman cohabit for a number of years, here mentioned number of years, it will be presumed under Section 114 of the Indian Evidence Act that they live as a husband and wife. They may presume the husband and wife and children born to them will not be illegitimate. So it's deemed to be a legitimate. Here mentioned will not be illegitimate. So deemed to be a legitimate one. So the born out of such children born out of such a living relationship is legitimate one. Okay. Okay. Then Indra Sarma versus VKV Sarma in 2013. The following Supreme Court requested the Parliament to enact a new legislation based on certain guidelines. Till now, there is no legislation for regulating the living relationship. So, the Supreme Court requested Parliament to enact a new legislation based on the certain guidelines given by it. The Indra Sarma versus V Sarma 2013. What are the guidelines? The following are guidelines given by the Supreme Court. First one is duration of period of relationship. There is no mentioned in specific period. Here mentioned duration of the guidelines to the Parliament, requested to the Parliament. The duration of a period of a relationship, shared household, polling of resource and financial arrangement, domestic arrangement, sexual relations, and children socialization in public. These guidelines should followed by requested to the Parliament to enact a new legislation. Okay. The marriage institutions transformed Hindu marriage, Christian institution transformed into living relationship. And in the new marriage, the marriage institution is transformed nowadays. Like a same gender marriage is also transformed. So எவ்வளோ இப்போ மேரேஜ் இன்ஸ்டிடியூஷன் ட்ரான்ஸ்ஃபார்ம் ஆக த பார்லிமெண்ட் வந்து ஷுட் எனாக்ட் நியூ லெஜிஸ்லேஷன் டு தட் பர்டிகுலர் marriage institution. So the Supreme Court requested to the Parliament enact the new legislation the following the guidelines. Indra Sarma versus VKV Sarma in 2013. And that 2F of that 2010 Act, I already told, and the 2F, the joint family. The Supreme Court in the recent judgment given an expanded meaning of expression of joint family. That 2F mentioned 2F of the Protection of Women's and Domestic Violence Act. And that joint family is not comes under Hindu joint family. Here, the joint family is living relationship and domestic relationship joint family. And the judgment is the Prabha Dyahi versus Kamalesh Devi 2012, a recent judgment. The court held that the joint family does not mean a joint family as understood in Hindu law. It would also include those persons who are living together or jointly as a joint family, such as foster children who live with the other member who are related by consanguinity marriage or by adoption. So the joint family is expanded meaning under that judgment. Okay. 2F of the Protection of Women from Domestic Violence Act 2005. Okay. So that's all. That next previous year questions and other MCQ questions. We already discussed in which of the case did Supreme Court held that relationship in the nature of marriage under Domestic Violence Act 2005 must also fulfill some basic criteria. Merely spending weekends and together or one night would not make it domestic relationship. The question is asked in June 2019 NTA net question. The answer is D. Veluchami versus D. Pachama. That case only would not comes under domestic relationship. The two grounds. One is merely spending weekend together or one night is would not make it domestic relationship. The D. Veluchami versus D. Pachama. Next, second question is Which of the following judgment do not deal with the matter of living relationship? Asked in November 2021 NTA Net. The Indra Sarma versus KV Sharma is we discussed, and the Supreme Court has a request to the following guidelines to the Parliament to enact the new legislation for regulating the living relationship. Indra Sarma versus KV Sharma. Then Kuspo versus Kanyamal is living relationship comes under right to life, Article 21. Chanmunia versus cases comes under rights of the parties. So the Sarda versus Dharampa versus not discussed under living relationship. The answer is 2. And third one is, which of the following judgments held that living together as a right to life under Article 21? And the answer is Kuspa versus Kanyamma. Which of the following section defined the domestic relationship as a relationship between two persons who live or have at any point of time live together in shared household under Domestic Violence Act 2005? The answer is section 2F of that 2005 Act. Which of the following judgment held that women in living relationship are equally entitled to all the claim and reliefs which are available to legally vetted wife? All the claims and reliefs, the maintenance rights, that comes under Article section 125 CRPC. The woman includes, wife includes woman, held in Chanmunia versus Chanmunia Kumar Singh. The answer is 4. The maintenance rights. The last question is, which of the case did Supreme Court held that relationship in the Marriage under Domestic Violence Act 2005 must also fulfill some basic criteria? If a man has a keep whom he maintains financially and used principally for sexual reason or potentially as a slave, then it would not be considered as a relationship in nature of marriage. Would not consider. The 2 grounds are mentioned. Would not consider as a relationship in nature of marriage is mentioned in D. Veluchami versus D. Pachayammal. So the first question and the last question is D. Veluchami versus Pachayammal. The 2 grounds are would not be considered as a relationship in nature of a living relationship. The conclusion is the living relationship is nature of marriage. It will be considered marriage itself. So it's not illegal, but totally do it legally. Okay, it regards the rights of parties. The three rights of parties: the maintenance rights and domestic violence rights. And adoption does not give adoption rights and legitimacy of children. So the children, the child born out of such a living relationship is a legitimacy one, not a illegitimacy. As there is no proper law on the subject matter, there is a still need for the proper legislation. So there is no proper law. Right now, the position of the parties will vary from case to case on basis of the past case law, which a judge might or might not overrule any time. So the Parliament to enact the legislation for to regulate the living relationship. And it's my bibliography: LMS LJRF platform, Family Law series, Family Law 1, Protection of Women from Domestic Violence Act 2005, RGNLU Law Review, and livelaw.com. Thank you.
അങ്ങനെ നോക്കുമ്പോൾ നമുക്കിത് മനസ്സിലാവും. Fees 80 Article 80 is what about the composition of the composition of the